All right, let's get into this explainer. Look, if you're a law student wading through administrative law right now, you already know that reading through government gazettes and official service codes can honestly feel like trying to decipher an ancient language. So today, we're taking the highly technical Jharkhand Government Servants Classification, Control, and Appeal Rules of 2016, and we're translating the whole shebang into a dynamic, step-by-step procedural playbook. We're going to bypass all that dense legalese and just extract the core mechanics of how state powers actually apply to its own workforce. To really grasp administrative justice, we have to start with one crucial question. What exactly happens when a civil servant goes off the rails and is accused of breaking the rules? We're going to track the entire life cycle of a disciplinary proceeding today. We'll go from the very first moment a government servant is accused of misconduct, all the way down to the final verdict. It is a really fascinating look into the actual machinery of government accountability.
So here is our procedural roadmap for today. First up, jurisdiction and classification. Second, the rules of suspension. Third, minor versus major penalties. And finally, the inquiry procedure.
Okay, let's kick things off with Part 1, Jurisdiction and Classification. We need to figure out exactly who these rules actually govern.
Right off the bat, Rule 3 gives us a major legal technicality, and it's one you'll definitely want to remember. These rules apply to the vast majority of Jharkhand government servants, but they explicitly carve out exceptions. Basically, they exclude casual employees, members of the All India Services, like your IAS or IPS officers who follow federal rules, and anyone whose employment can be discharged on less than a month's notice. They also totally exclude personnel like police officers or jail staff simply because they're already governed by their own dedicated manuals.
Now, check out this strict legal distinction made in Rule 2. As a government servant, you have an appointing authority. That's the office that officially hired you. But you also have a disciplinary authority. Now, while they can sometimes be the exact same person, the disciplinary authority is the one specifically empowered to impose penalties on you. And in administrative law, this is huge. If the wrong authority issues a penalty, the entire proceeding can literally be thrown out in court on that technicality alone.
Part 2 of the rules, specifically Rule 6, breaks down how the state categorizes its massive workforce. It classifies everyone into groups A through D strictly, and I mean mathematically, based on their designated pay bands and grade pays, which are assigned by the Finance Department. Group A represents your top-tier administrators, all the way down to Group D for your base-level support staff.
Moving right along to Phase 2, the rules of suspension. This is basically the holding pattern for civil servants. Now, before we dive into the details, you have to remember that, legally speaking, suspension is not actually a punishment. It acts as a holding pattern for an accused civil servant while an investigation plays out. And the absolute magic number for your exams, found right in Rule 9, is 48 hours. This specific number activates one of the most powerful mechanisms in this entire rulebook.
So why 48 hours? Well, under Rule 9, Sub-Rule 2, if a government servant is detained in police custody on a criminal charge for a period exceeding 48 hours, they are automatically placed under what is known as deemed suspension by the appointing authority. No formal departmental meeting is required to initiate it. Boom! The sheer fact that you've been sitting in custody for 48 hours legally activates your suspension from duty, backdated to the exact date of your detention.
But under Rule 10, a suspended servant isn't just tossed out into the street with zero income. Because suspension isn't a final guilty verdict, the employee is legally entitled to a subsistence grant. Initially, this payout is equal to the leave salary they would have drawn if they had been on half-pay leave. What's super interesting here is that the disciplinary authority reviews this after the first 12 months. They can actually increase or decrease that payout by up to 50%, entirely depending on whether the employee themselves is the one causing delays in the ongoing investigation.
All right, let's hit Section 3, Minor versus Major Penalties.
Rule 14 perfectly delineates the stakes into two very distinct categories. Minor penalties include things like a formal censure, withholding standard pay increments, or forcing the employee to pay back financial losses they caused the government. It definitely dents a career, for sure. But major penalties? They are completely devastating. We're talking withholding promotions, demotion to a lower rank, compulsory retirement, or the ultimate punishments, removal and dismissal. And take note, there's a vital legal difference there too. Dismissal completely disqualifies a servant from ever holding future government employment, whereas removal generally doesn't.
Now here's a classic legal gotcha hidden in Explanation 3 of Rule 14, and you'll absolutely want to highlight this in your notes.
A warning given by a superior to criticize an employee's carelessness is specifically defined as not being a penalty under these rules. Even if a warning gets entered into the employee's official character rule, it cannot be legally equated to a formal censure. However, just a heads up, if an employee racks up multiple warnings with no improvement, well, that can definitely be used against them later.
And finally, we reach the crown jewel for law students. Part 4. The Inquiry Procedure. The administrative trial for major penalties.
This is where administrative law truly starts to mimic a courtroom. Rule 17 lays out this administrative trial. First, they have to draft distinct, definite articles of charge. Vague accusations simply will not hold up. Next, it mandates actually serving these charges, along with a list of evidence and witnesses, to the accused. After that, the civil servant must submit a written statement of defense. Only after all this strict pretrial paperwork is totally completed do we move to the final stage, where the inquiring authority finally begins holding formal hearings. So who manages the prosecution side of this quasi-judicial process? The rules state that the disciplinary authority may appoint a presenting officer. Just think of the presenting officer as the state's prosecuting attorney in this specific context. Their entire job is to present the case and the evidence on behalf of the disciplinary authority.
But listen, Rule 17 heavily emphasizes due process. This isn't some kangaroo court. The civil servant has the explicit right to inspect specified government documents. They have the right to cross-examine the witnesses brought forward by the presenting officer. They can introduce their own relevant evidence and even call their own witnesses. And ultimately, they have the absolute right to present their own defense, either orally or in a written brief.
Once all the evidence is heard and the inquiry wraps up, the inquiring authority cannot just hand down a simple guilty or not guilty verdict. It doesn't work that way. Under Rule 17, Subrule 23, they have to prepare a highly detailed, comprehensive record. Crucially, this record mandates a specific assessment and a specific finding for each and every individual article of charge, complete with the legal reasoning for that finding.
Okay, I want to show you another incredible technicality. Looping back to Rule 9, Subrule 5, imagine a civil servant is dismissed. They appeal to a real court of law, and the court throws out the dismissal. Great, right? Well, if the court throws it out purely on technical grounds, say somebody messed up the paperwork, rather than exonerating the employee on the actual merits of the case, the disciplinary authority has a serious countermove. They can order a further inquiry into the original allegations, and doing that instantly triggers a deemed resuspension of the servant, backdated all the way to the original date of dismissal.
Rule 17, Subrule 1, really underscores the entire philosophy of Part 6. The state wields immense, life-altering power over its employees' livelihoods, but it cannot arbitrarily impose major penalties. It has to strictly adhere to this highly structured legal framework. It is essentially the ultimate shield of due process.
So, as you study these administrative rules and gear up for your exams, I want to leave you with a final thought to debate with your study groups. Looking at the sheer density and complexity of Rule 17, ask yourself, do these extensive procedural safeguards truly protect civil servants from the arbitrary exercise of power? Or do they just create an inescapable maze of bureaucratic delays that make it nearly impossible to quickly discipline actual misconduct? It's the ultimate balancing act of administrative law. Thanks for joining me on this explainer, and keep questioning the mechanics of the law.